Good morning to those of you who have joined us. We'll just wait a little longer. We're expecting something like 35 people. We're up to 22. This is the first of two seminars, legal webinars with Richard Pulford from Payne Smith. We're now up to 24, and I will be handing over to Richard in a minute. Just to let you know that you can ask questions. Please put them in the chat box rather than the question and answer box, because Richard will be able to go through those a lot quicker than looking at the question and answer box. We're now up to 27 of you, so we're getting close. We'll just leave it another couple of minutes, and then I'll hand the host over to Richard, and he will start the presentation. By the way, the PowerPoint that Richard is using today will be sent to you all following today's webinar. And of course, for those of you coming back next week, the same will apply. We did have a little bit of a problem to begin with. I managed to have my sound on nothing, so I couldn't hear Richard. Anyway, so we're all right now. I can definitely hear him. Right, we've got 29 people in. I'm going to go and hand over to Richard. Make host. I'm making Richard the host, and he will now be able to use his PowerPoint, etc. Anyway, over to you, Richard, and thank you very much.
No problem at all. Right, welcome everyone. Today's going to be a little bit of a whistle-stop tour of a number of different topic areas that we think are going to be reasonably useful for you. By no means should this be sort of an exhaustive list of everything that you can possibly need to know. Unfortunately, there's just not time to do these sort of things. And if this works out reasonably well, these first two webinars, then we might do additional ones on top of it. If you think that would be useful, then obviously let Tad know what topic areas you think would be useful, and we can see if we can sort that out for you. Now, the way it's going to run is it's two different webinar sessions. So I'm going to go through what's going to go on in the first session in just a minute, and then feel free to ask questions. Now, we're not going to be able to cover everything in as much detail as we would normally do because of the time constraints that we've got, and some of the topic areas that we're going to be covering leave room for a fair amount of discussion as part of them anyway. So we will be covering that. If we're going through questions at the end, as Tad mentioned, put it in the chat box, and we will then go through it at the end of the session. If it's something that we're going to be covering more in the second session, then I'll let you know at the start what we're going to be covering in the second session. I'll probably leave those for the ones that are going to be organised a week today, assuming that you're all going to be there for it. So let me just share my screen so we can get the PowerPoint up in front of us. Right, okay. So just a little bit about me to start with. I'm not going to go on for a long time about that, given the time frame that we've got. But as Tad mentioned, I'm a solicitor at Payne Smith Solicitors. Been doing this for sort of in excess of 10, 11 years now. Now, as a firm, this is all that we do. We do landlord and tenant matters. And so we deal with these sort of things on a day-to-day basis. Now, one of the inherent problems of ever getting a talk done by a solicitor is that you tend to come out of it thinking the world is going to end, that there's no possible way that you can cover everything that you're going to, or make any money doing what you're doing. And ultimately, that's inherently because you only ever get solicitors involved when things go wrong. So I have a slightly deluded idea as to how often these sort of things go wrong, but I do often think it does make sense, and it is sort of a useful way of dealing with these sort of things to have a worst case scenario approach. That approach can be lessened if necessary. You can take commercial decisions as necessary, and I would encourage you to do so where it is appropriate, but try and have a matter-of-fact point in terms of the law, so that you're never ever caught out, or you can try and avoid being caught out as sort of tester cases on any of the points that we're going to be raising. Okay, so 2 different webinars. In the first one, we're going to be covering different types of tenancy agreements that can be entered into, deposit protection requirements, little bit on tenants' obligations and landlords' obligations, and we're going to finish off with a little bit on electronic signatures and what sort of things are allowed, which things you need to be somewhat careful on. Now, the second session is going to be more in relation to things like deposit disputes, repairing obligations, notice requirements, and any changes that we're having sort of mid-tenancy. So bear in mind with the questions that you're going to raise, that is going to be something that we're going to be more focusing on the second session. Okay, so we're going to first focus on types of tenancies that you can enter into. Now, it's one of the key component parts that you need to be able to identify at an early stage, because what type of tenancy you enter into then filters into what additional works you need to consider moving forwards. So whether you enter into an AST or whether it should be a common law tenancy then links to whether the things like the Tenant Fees Act applies, whether the deposit protection requirements will kick in for tenancies of that kind. So it is crucial to be able to identify, given the scenario that you've got, what type of tenancy you should be entering into. Now, when you're entering into tenancy agreements, it isn't a be-all and end-all what the tenancy agreement is called. Ultimately, a tenancy agreement is read to be whatever it should be. So if it fits the scenario of being an AST, a landlord can't just decide to enter into a license agreement or decide to enter into a common law tenancy because they want to get away from their responsibilities from a deposit protection standpoint. So that's where you as the relocation agents will need to be able to identify that, so you can call the landlord to account, and if they are trying to sort of cut corners in terms of their legal obligations, that you can call them on that. You can say, no, this is your requirement to do, and if you're not going to do it, then it may mean that you've got that your client is subject to or has a claim against the landlord at a later date. So most common type of tenancy that you're going to be entering into is in relation to an AST. It's all covered under the Housing Act. When you're dealing with ASTs, firstly, there is no minimum term that is required. There used to be a minimum term of 6 months for ASTs, which is why there's been a lot of holdover when you're dealing with managing agents and landlords who believe that there is a minimum term for these sort of tenancies. Now, what there is with an AST is a tenant is granted security of tenure for at least 6 months. So a court won't make an order for possession unless there's a breach before that initial 6 months has passed. It's why the Deregulation Act is brought in relation to service of notice, so that Section 21 notice can't be served in the first 4 months, and then obviously needs to give a minimum of 2 months notice thereafter. So it's less than 6 months, therefore can't be an AST, or has to be some sort of short let agreement, is not actually the case. Circumstances dictate that it should be an AST, then it will remain an AST. So with that, it is if you are granting a tenancy, so you're giving sole use and occupation of a property for rent, it's granted to an individual. So this won't be if the tenancy is in the name of a company, and it's within the threshold that we're going to go through in just a second for the rental that is achieved on those particular properties. Things that you need to be aware of, this won't be particularly relevant for new tenancies that you're entering into, but key dates when you're trying to determine what sort of tenancy has been created. Housing Act came into force as of the start of 1989, so Housing Act 1988. So from that date, it would automatically, the default tenancy was an assured tenancy. As of February 1997, that changed. Default tenancy from that point onwards was an AST. So if you're looking at a historic tenancy, tenant's been in there for a long period of time and is looking for your advice in relation to that tenancy, general scope of those timeframes will give you an idea as to the type of protection that those tenants may be entitled to. Now, when you are entering into an AST, there will be those certain obligations that the landlord will have. They will need to make sure that any security deposit is registered. And we are going to go through that in a little bit of detail in just a second. But the landlord will need to make sure they comply with that. Very strict requirements for not doing so. It's one of the reasons why a lot of landlords will try and avoid ASTs if possible. But as I mentioned earlier on, if it fits the criteria, if it fits the definition of what constitutes an AST, then they don't have a choice. They will need to make sure that protection has been carried out correctly. Now, there are a couple of exemptions to ASTs. Obviously, you all know that you don't always deal with ASTs. So if rental is over £100,000 a year, then it will be a common law tenancy that's being entered into. If the tenant is not an individual, so if the company is a limited liability company, they're treated as a separate legal entity able to enter into a contract in the company's name, and therefore it will be a type of company-let agreement that's being entered into. Now, in certain circumstances, there may well be landlord living in the property as well. Now, this does become a little bit more complicated because it depends on where the landlord is living and the layout of the property, whether it is just a room in the landlord's house or whether it was a converted flat. So if it's just a room in the landlord's house, then in all probability it will be a lodger agreement. If it's a converted flat, then it's likely to be a common law tenancy because you're granting a tenancy in those circumstances. The tenant is able to sort of exclude all others from the property that they're entering into. Next one is one where it's not the tenant's main or principal home. So if you're...
Excuse me, Richard, you're not forwarding the slides.
The slides are not coming up, are they?
Well, we've only got the first one.
Okay. Try and have that again. Is that better?
Thank you, Rachel Harvey, for that.
Perfect. So if it's the tenant is not their main and principal home, then it is likely to be a common law tenancy. Now, always be cautious when you're dealing with those sort of tenancies, less so for yourself, but more so for landlords are likely to be cautious because there's no real fixed definition as to what constitutes someone's main or principal home. So if someone is, let's say, has a property in countryside but works in the city, so takes out a letting for just during the week, landlord's probably going to argue it should be an AST because they're spending more time in that property. Now, the reason they do that is because it protects the landlord more. If they protect the deposit, it can be viewed to be an AST or a common law tenancy, but at least they've made sure that they have registered that deposit and therefore not going to have that penalty amount that is made against them. And then when they're serving notice, they would just comply with both the requirements of an AST and a common law tenancy. Equally, if the property is used for agricultural purposes, a lot less common. However, it is likely to not be an AST on that basis. Now, one of the key things that comes along with an AST and needing to enter into an AST is to make sure the deposit is registered. Now, this is something that hopefully is not going to be new to a lot of you. However, it is something which is constantly done wrong by landlords. It's one of the key and most obvious errors that a lot of landlords make in terms of the pre-tenancy setup process, and has been subject to a number of different pieces of case law in sort of recent months and years. So something you need to be aware of, not even necessarily to make sure that your agent's doing it correctly, but sometimes just to advise your client that they may have leverage slightly later on if it's done incorrectly by the landlord or their managing agent right at the beginning. So the requirement as far as the landlord's concerned is to make sure that the security deposit is registered and protected within 30 days of receipt of any part of the deposit. So it's not from the start of the tenancy, it is actually from when the deposit is paid. Now, if you pay the security deposit well in advance of the start of the tenancy, that will mean that 30 days will start and probably expire before the start of the tenancy is actually started. So it's not actually the fixed date that the tenancy is going to be entered into, it is when that security deposit is actually paid. Now, the requirements are to use one of the 3 government-approved schemes, TDS, DPS, My Deposits, and either the insured or custodial scheme for each of those schemes. The landlord will have a requirement to make sure they serve prescribed information, which is essentially a document which is produced by the deposit scheme that you use, covers the circumstances that if a dispute is entered into at the end of the tenancy, so that all parties know what they should be doing, what the procedure will be, what is going to be expected from all parties, essentially what they need to do. Now, that information cannot be served validly on a tenant unless it is signed by the landlord or their managing agent, and done so within 30 days of receipt of that deposit. It can't be done before the deposit is taken, but it has to be done within that first 30 days. And it needs to be done correctly and therefore needs to be signed. Having a blank copy that's sent over before the tenancy is received as a coverall is not going to protect the landlord in these sort of circumstances. Now, a deposit, when taken for an AST, will require the agent or landlord, whoever is holding the deposit, to hold the deposit as what's called stakeholder. That means they can't release that security deposit until such time as either there's been agreement in writing by both the landlord and the tenant for any deductions or any allocation of the deposit, or until there has been a determination made by either the deposit scheme and it's gone through dispute or through the courts. Until that point, if the landlord or tenant is not giving their authorization to do so, the agent is not authorized to pass that money over, no matter how reasonable the claim may be. So if you are looking for your deposit back, it may well not be the agent's choice as to whether that money is going to be returned. They may well need to take instructions from their client, being the landlord, before they release that money. And if the landlord is being difficult, it may well be that you need to try and force their hand, either by going through the adjudication process or by making a claim through the courts. Now, there is another way of holding a deposit, being holding the deposit as landlord's agent. Now, this will not happen when it comes to ASTs. The deposit has to be held as stakeholder. However, be aware, when you are dealing with a common law tenancy company-let agreement, every now and again, an agent will hold the deposit as landlord's agent. Now, what this essentially means is they hold it pending instructions from their client. So they're only waiting for instructions from the landlord as to how to release that money. They don't need to make a determination as to the reasonableness of the claim, and therefore it would be up to the tenant to take that up with the landlord directly if they disagree with what instructions the landlord has given that managing agent. So be aware when you're looking through those tenancy agreements to start with, check how that deposit is being held. And if it's held as landlord's agent, be aware of what the ramifications are. And if you can, try and get them to change it as stakeholder, because it gives your client a little bit more leverage in terms of those negotiations. As I say, shouldn't be applicable for ASTs, but something to be on alert for. Now, the requirement to actually protect the deposit will be with the landlord. The landlord has that overall responsibility. Whether they contract out of that by giving their agent authorization to do so is between the landlord and the agent. Now, as far as you're concerned in acting for the tenant, it doesn't really matter who does that as long as it is within 30 days of either of them having received the money. So let's say you paid the money to the managing agent and it took them 20 days to get that money transferred over to the landlord. And then it took them 20 days then to register the deposit. Then they're outside of that 30 days to protect that deposit. It's not from when the person who is going to protect the deposit receives the money. It is from the point that you or your tenant pays the money to either of them, to their representative. As soon as that money is transferred over, the time frame for that 30 days starts ticking. So in terms of their obligations, that is what to do right at the beginning of the tenancy. Now, there will be circumstances where that information needs to be updated. So prescribed information doesn't necessarily need to be served by the landlord at renewals. However, a lot of landlords are well inclined to do so to make sure they're covering for any mistakes that they may have made at the start of the tenancy. So it might be included within extensions. It's not an absolutely mandatory obligation. The only time you will need to make sure that the new prescribed information is updated is when there is a material change in how that deposit is being held. So if the landlord has changed, if the tenant has changed, if the deposit scheme has changed, and certainly in my view, if the deposit amount is changing, the deposit scheme should be updated to reflect the amount that they're holding. Now that one, given the Tenant Fees Act, which we are going to go through in a little bit more detail in just a minute, isn't necessarily incredibly clear, and you'll get conflicting arguments from deposit scheme providers, landlords, and the legislation just isn't incredibly clear on it. My view is, if you're in front of a judge would want prescribed information to be reserved if that deposit amount has been changed. So it might be something to push your landlords to do in the event that you're dealing with an AST and the deposit has been reduced by virtue of the Tenant Fees Act. Now, mistakes will be made in relation to deposits. It just happens, timeframes missed, information which either party thought had been sent out hadn't actually been sent out. And so these can be, in some situations, resolved, in other situations not. So if the deposit hasn't been registered within that first 30 days, there is no way for the landlord to remedy that fault. Before serving a valid Section 21 notice, they would need to make sure that deposit has been returned. If it is just prescribed information that was missed off or it wasn't served correctly, that is something the landlord may be able to remedy by reserving prescribed information. Doesn't absolve them of the monetary penalties, but it is likely to, unless you're dealing with My Deposits as the deposit scheme, it's likely to result in prescribed information having been validly served, and therefore the landlord able to serve a valid Section 21 notice. Now, there are a number of penalties in relation to deposits, and ones which are incredibly severe. So failure to register the deposit properly, or failure to comply with some of the requirements of the individual scheme, like the prescribed information and terms and conditions of the scheme, or it hasn't been signed correctly, as we're going to go on to in just a second, then can give rise to a penalty amount of between 1 to 3 times the deposit amount, and the deposit to be returned. Now, the thing to be aware of with that is that's not necessarily a one-time only penalty. So if the landlord doesn't protect the deposit right at the beginning and then extends the tenancy afterwards and still forgets to protect the deposit properly, and only realizes maybe after the 3rd or 4th renewal, then it may be that they've got a claim for between 1 and 3 times the deposit amount for the first tenancy and every subsequent extension afterwards as well. So be aware of it. These sort of penalties can start to rack up if the landlord doesn't do what they're supposed to be doing. Now, one just to keep an eye on is in relation to the signing of prescribed information and who is actually authorized to do so. Now, the Deregulation Act confirmed that agents were able to serve prescribed information on behalf of the landlord, but there is a couple of cases that are going through at the moment trying to deal with the issue of the Companies Act and how that information needs to be served and signed. So Section 44 of the Companies Act says any notices that are being signed by a company need to be signed by either 2 directors or a director and a witness. Now, prescribed information is considered to be a notice, and therefore, if the agent has signed on behalf of the landlord or the landlord is a company, some agents are finding that they haven't actually signed the prescribed information correctly. Now, this is going through, forget whether it's the Court of Appeal or Supreme Court at the moment, but the Northwoods case at the moment. Hopefully, we're going to get some form of confirmation over that over sort of the next sort of 3 to 4 months. Hopefully, something to keep an eye on, because that could open the floodgates in terms of potential claims that tenants may be able to have, if it sets out a precedent for how prescribed information should be served and can be served by signed by agents, because it was likely to apply retrospectively, and a lot of agents will not have signed in accordance with the Companies Act because they didn't know that they had to. So that's in relation to ASTs. Company let agreements. So when you're dealing with a tenant who is a limited company, they're considered to be a separate legal entity. It won't apply for partnerships that don't have limited liability or sole traders. It physically has to be a limited company because they are behind the veil of incorporation, or directors are behind the veil of incorporation. They are considered to be an entity in and of themselves. Now, with these, there is no requirement to sort of register the deposit, and it is purely a contractual agreement between the parties. Now, in these circumstances, the occupier is going to be the licensee of the tenant. Now, it's often employees or someone that is affiliated, director of the company, who is going to be living in there for residential purposes. However, in those circumstances, it is the company that takes full responsibility for the acts of their occupiers. So if the company says, puts in someone into the property and they are causing damage, they're causing antisocial behavior to sort of be prevalent at the property, they're the ones that are going to be liable. Non-payment of rent, again, it's the company themselves that are going to be liable. Now, for these, the contract is going to be key. Company is not protected to the same degree by the statutory protections that apply to a lot of ASTs. Consumer protection requirements in relation to clauses not being unfair generally apply against individuals, do not apply when the contract is entered into with a company. So you need to be really vigilant when you're looking through these agreements, just to make sure any changes that you need made to the contract are entered into beforehand, because it's a lot more difficult when you're dealing with a company-let agreement to get clauses sort of argued away in terms of being unenforceable for being unfair. The contract is what the contract is, so you really do need to make sure you're looking through it carefully, particularly in relation to things like unfair terms in your contract, or where notices need to be served, how the deposit is being held, like we covered just a second ago. Now, recovery of possession for a company-let agreement is a lot more complicated. So it's not Section 21 notices and Section 8 notices that are being served. It is generally a notice to quit if the landlord is looking to recover possession of the property, or forfeiture in the event of non-payment of rent. Now, forfeiture doesn't always require notice to be served. A landlord can just take action to recover possession of the property through the courts. And these notice periods have not been impacted at all by coronavirus throughout. So companies are expected to make sure that they are complying with the terms of their agreement. And if the landlord is looking to serve notice, then it might not be the same level of notice that you would normally anticipate that your clients are going to be served. So at that point, as necessary, make sure you're taking appropriate legal advice to make sure that you're protecting your client from them entering into or being evicted from a property slightly earlier than they were anticipating they would be. So general notice provisions for these. So if the landlord is looking to rely upon a break clause, it's whatever the break clause says in your contract. If the landlord is just trying to rely upon possession at the end of the fixed term, they rely upon what's called the effluxion of time, i.e. that the contract has naturally come to its end. and therefore possession is required. And if the tenancy has gone periodic, it will be a notice to quit that the landlord looks to serve, which needs to give a minimum of 4 weeks notice, but also a minimum of a period's notice. So if rent's payable monthly, it will need to be at least a month, and it will need to expire at the end of a period of the tenancy. Equally, if rent is payable slightly less frequently, so if it's 6 months rent, it will be a minimum of 6 months notice. Forfeiture, no notice provisions, no notice needs to be served on these. It is just that the breach has been existent, most commonly rent, not been paid for 14 days after being lawfully due, and the forfeiture clause in your tenancy agreement is strictly applied.
Richard, there's a couple of questions relating to ASTs in the chat box that you might
Sure.
like to quickly look at before continuing.
Sure, let me have a quick look.
Starting with, I think, Kerry Chislett asked a question, followed by Kelly Bell and Julie Beaton.
Right, okay. So Kerry's asked if an agent stipulates they are placing the deposit in a deposit protection scheme, and then afterwards says the statutory deposit scheme set out in the provisions of the Housing Act do not apply to this tenancy. How does this impact the tenant's rights? So if someone has contracted out or contracted that they are going to protect a deposit in a situation where it is a company let and therefore not a requirement of them, then you can try and claim breach of contract for failing to do so. However, in terms of an actual penalty that is associated with that, there really isn't much that you're able to do, mainly because a lot of the deposit schemes just don't protect these sort of deposits. So the loss that's been suffered might, you could argue, be that you assumed that you would have the process of the adjudication that might be entered into, but not necessarily, because if a deposit scheme was never going to protect something, then you haven't actually lost out by them agreeing to do it in the first instance. You need to be able to show an actual loss. Now, just by doing this, they're not opening up the landlord to a claim of between 1 and 3 times the deposit amount for not protecting it, because those simply only apply for ASTs. So in reality, they're probably in breach, but the actual amount of any sort of penalty would be incredibly little, if at all, because the option was never really available in the first instance. Kelly's asked, can a company sign an AST agreement instead of a company let agreement? And in that situation, no, they can't. Again, if a contract will be read to be whatever it should be. So if a company is entering into a contract and they are a separate legal entity, it doesn't fit the criteria of needing to be entering into an AST. So whilst they might be signing an AST, it is a company let agreement that they're entering into. Right, so I have a company let being negotiated with Savills and they're using an AST. They say because it's under 100,000 rent, do I need to worry about this? Ultimately, again, it depends on what the terms of that agreement are. If they're entering into an AST and it's with a company and it's a separate legal entity that they're entering into, again, it might be something that you can pick up on later on when they're serving notice to say, yeah, they haven't served notice correctly. Ultimately, though, they may well be doing so either because they're concerned that the company agreement has, or the company themselves don't satisfy the requirements for entering into a company-let agreement. Ultimately, that would be their call as to whether they do that. But if it is a company, a separate legal entity, then it should be a company-let that they're entering into. How difficult is it to negotiate a company let with a company that is not UK based? Ultimately, this depends entirely on the agent or the landlord. Companies that are abroad is something that a lot of landlords and agents get scared of purely in terms of enforceability. So being able to enforce against a company that has no base in England and Wales means jurisdiction, should they leave with loads of arrears, is more difficult. Being able to satisfy them that there's the list of directors who is appropriate to be able to sign the document. is more difficult because they're not on company's house. You can't do a quick free check on company's house to establish who are the directors. You're not necessarily going to have the same articles of association that you might have for normal types of companies who are based in England and Wales. So really it depends on the individual agent and the landlord as to sort of cold feet and how nervous they are with those sort of tenancies. So can be difficult. To an experienced agent, it shouldn't be anything that they are scared off of. However, what they normally will ask for, or certainly would be well advised to ask for, would be a England and Wales based guarantor, so that if the company sort of leaves, or the occupier leaves, and the company sort of just is non-contactable, that they've got an individual that they can pursue through the courts for any damage or rent arrears that have built up. So if you get a nervous agent and your landlord and your client wants to take out a tenancy, that might be something that you can offer to them to appease them. Right, okay, so a little bit now of an update of the Tenant Fees Act. Now, this is another piece of legislation that is only going to apply for certain types of tenancies. So you're dealing with ASTs, student lets, license to occupy. So if you're dealing with common law tenancies, company let agreements, these fees or this piece of legislation will not apply in those sort of circumstances. Okay, so first thing to bear in mind is when and how this legislation applies. So it applies for all new tenancies from June 2019, and then all applicable tenancies from the 1st of June 2020. So if you have an AST student let license to occupy, then the Tenant Fees Act will now apply. This applies for any extensions that you've entered into as well. So if it's just a new tenancy that was entered into before the Tenant Fees Act but has been extended thereafter, the Tenant Fees Act is going to apply. So this will stop a situation where tenants are being forced to pay over significant amounts of money before the tenancy has ever properly been entered into, and to the agent cover the pre-tenancy checks. The idea is it's to avoid a situation of a potential conflict of interest between the parties. There are a number of exemptions to that. The first one of which is rental. So obviously, tenants is still expected to pay rent. There is very few restrictions in terms of what can be charged in terms of rent, mainly because whilst you're not supposed to increase the rent to account for the loss of costs that applied to a tenant in the first instance, if everyone is increasing rent, and I know rents are increasing at a fairly rapid rate at the moment, if it's just everyone's doing it, how do you argue that that's a breach of the Tenant Fees Act and not just the market determining what the rental should be? The one key thing when it comes to the rental that you need to be aware of, and you can highlight if necessary, is that the landlord is not able to charge more for the first month's rent than they would for subsequent rents afterwards. So they can still take a lump sum up front, say 6 months up front, but the value of that first month's payment needs to be equivalent to what it would be for the rest of the tenancy. So if rental is £1,000 a month, you can take 6 months up front being 6,000 and then monthly thereafter, but you couldn't, let's say, take 2,000 for the first month and then 1,000 for every month thereafter. It's a direct breach of the terms of the Tenant Fees Act. Where this gets slightly more complicated is in its applicability for things like to put security deposits, holding deposits, or breaches of the terms of the tenancy. So security deposit, you now have maximum amounts that can be taken. For rental up to 50,000, the landlord is only able to take a maximum of 5 weeks deposit. Between 50,000 to 100,000, so 50,001 to 100,000, they can take 6 weeks deposit. That is the maximum that they're able to take. They can't take additional amounts or anything on top of that. So in the past, a lot of landlords or agents, if pets were being moved into properties, would ask for a pet deposit. This fits under the definition of a security deposit. And so as a cumulative total of all security deposits taken for a tenancy, it cannot exceed that threshold of the 5 or 6 weeks, depending on the cumulative rent for the year. Now, this should be updated as and when applicable. So any new tenancies, obviously, you're going to know that criteria that needs to be met. If it is a renewal that's being entered into, the landlord also should be addressing the amount of deposit that's currently being held. In those circumstances, they should be adjusting it so that at that time, they are not holding in excess of the either 5 weeks or 6 week security deposit. It is based on the rental now, not necessarily the rental at the start of the tenancy. So if the tenancy started a long time ago, it may well be that the deposit started off as a 6 week deposit, but now by virtue of some rental increases that have happened over the years, maybe now it's a 5 week deposit. But that is something certainly the landlord should be addressing with yourselves as and when you're dealing with any extensions. And as I say, due diligence, if I was advising the landlord, I'd be telling them to update the prescribed information as well. So that might be something that you can address with them at that point also. Now, holding deposits are something which can also be taken by landlords and agents that start the tenancy before the tenancy is actually being entered into. The maximum amount they can take is up to 1 week's worth of rent. This is ultimately to give your clients security over the property, and it will mean that the property needs to be taken off the market during that time. The money doesn't go towards the cost of referencing. It doesn't go towards the cost of drawing up the tenancy like it had done in the past. It is purely in relation to if the tenancy goes ahead, it will be put towards either the security deposit or the first month's rent, or even returned to your client. If the tenancy doesn't go ahead, then the landlord can look to retain the holding deposit only if one of 3 criteria is made. Either the tenant has provided false or misleading information, which means that the tenancy can't go ahead. So not necessarily that that your client failed referencing, it needs to be false or misleading information that is meant that that's happened. If they failed their right to rent checks, or if your client has been the one that has been dragging their feet and that's the reason that the tenancy can't go ahead, they're not providing documentation, which would reasonably be expected in terms of the setup of a tenancy. Lots of landlords and agents are trying to hold on to that holding deposit, but call them out for it. Ask them what their justification for holding on to that tenant fee, holding deposit is, because in a lot of circumstances it is things like failed referencing or to offset against the referencing or drawing up tenancy agreements. And in reality, that is not a justifiable reason if it's an applicable tenancy under the Tenant Fees Act. Next one is in relation to breaches. So if your clients breach the terms of the tenancy agreement, the landlord is still able to recover that money from them, normally in the sense of a deduction from the deposit or a claim associated with non-payment of rent or interest, as long as the interest is limited to 3% above the Bank of England base rate and only payable after the rent has been outstanding for at least 14 days. That part hasn't really changed a great deal, sort of by the introduction of the Tenant Fees Act. The one thing to bear in mind in relation that has had a reasonable amount of updated case law now on is charges associated with changes to the tenancy, because these are limited to £50 or cost. Now, there was a recent case that went through the First Tier Tribunal relating to a property called 3 Layfield House. And this dealt with what is considered to be reasonable costs associated with this. Was in this case, it was an assignment that was entered into. And the landlord or agent tried to argue that their costs associated were referencing new client, inspection, creating of a new tenancy agreement, re-registration of a deposit. Those were physical costs that they had and therefore amounts that they can charge. And the tribunal said that wasn't the case, that £50 was an amount which had been included within the legislation, and therefore there needs to be good reason why you would go above that figure. So if you are dealing with an assignment and a landlord or agent is trying to up the fees, trying to argue costs, that may be authority that you can look to try and rely upon if necessary. It may also mean that a lot of landlords and agents, if they're aware of this up-to-date case law, maybe look to try and not agree assignments and instead look to agree surrenders and regrants of new tenancies, because there's a lot less in terms of restrictions for what can be charged for an early surrender of a tenancy when there's not grounds to end the tenancy under the agreement that you have. So charges that can be applied, but ones that certainly you can look to negotiate. If you're negotiating the terms of things like early surrender or variation, and you're getting some odd prices that are coming over from the landlord or their managing agent, ask them to justify their fee. Use the Tenant Fees Act guidance as your basis for saying how and why are you entitled to the charges that you're looking for. Because a lot of the payments, and I know this from experience, that are being demanded are done based on a tangential link to the Tenant Fees Act, or it has just been passed around the office that this is what we've always been charged, and there's not actually a statutory right to claim what is being claimed. And whilst I appreciate the fact I've just gone through a case which has determined a figure for the Tenant Fees Act, it is one that hasn't had a lot of case law for it. So it does give rise for significant arguments as to what might be applicable, particularly in relation to early surrender of a tenancy. Right, okay, so a couple more clauses and points to go through before I start taking any additional questions that you've got. Now, individually negotiated clauses are generally going to be your main scope for negotiating before a tenancy has actually formally been entered into. The rest of the tenancy agreement is normally a fairly rigid structure that landlords and agents don't want too much negotiation on. And really, if it's an AST, they normally don't have a lot of scope to do so anyway, because a lot of the rules in there are defined either with statute or what is deemed reasonable for those sort of tenancies, because consumer protection regulations require notices and clauses to be done in a particular manner. Where you do have a little bit of scope is in relation to these individually negotiated terms, particularly break clauses. So first thing to be aware of with the break clauses themselves is that they are incredibly strictly interpreted. So if the clause says something, both parties are expected to comply exactly with the wording of the break clause. And if they don't, the notice served is going to be deemed to be invalid. There is none of this, well, both parties knew what was intended, or that you must have known what we meant by this notice. The other side is well within their rights to say, this has a rigid structure, you were supposed to serve notice by a given date in a given manner, and it wasn't done that way. So when you are producing this or reviewing it, try and make sure that the clause is understandable, that it's relatively easy to comply with. There is no reason that you need to make a clause like a break clause wildly complicated, because it just makes it more difficult, not only for the landlord to serve notice later on, but also yourselves on behalf of the tenants as well. So the thing that you look at is what your client is actually looking for, because the break clause isn't defined in terms of it has to be in a particular manner. It's whatever's agreed between the parties. So are you looking for a one-off break clause, or are you looking for a rolling break clause? So is it just that notice can be served dead on 6 months and thereafter can't be used again? Or is the intention that it can be used anytime after a given date? And this is where you can start to use your expertise as your as sort of relocation agents to make sure your clients are fully informed. So if there's a one-off break clause, and let's say for argument's sake you're dealing with an AST, and the landlord is suggesting that they want a one-off break clause to end the tenancy as of 6 months, either party serving 2 months notice. Whilst that's fine for yourselves as the manager, as the tenant, or advising the tenant, what the landlord has done there is made a clause that they probably can't look to rely upon, mainly because they would need to also comply with the obligations of the Deregulation Act, which says that you can't serve notice in that first 4 months. And then you would need to give at least 2 months notice, meaning having a notice that expires dead on 6 months is nigh on impossible for the landlord. So not something you need to highlight to the landlord. It's their call to have a clause like that in there, but it might be something that you can highlight to your client when you're looking to negotiate the terms of that break clause, to say, just so you're aware, it's a one-off break clause. It's not something you can rely upon. It's not something that's going to be assumed to be rolling. It is whatever the clause itself says. And if there's any sort of ambiguity in relation to the interpretation of a clause, the general rule is a legal principle called contra proferendum, i.e. that the clause is read against the draftsman. So if there is any sort of ambiguity, or a clause could be interpreted a number of different ways, then in all probability it would be interpreted against the person who actually drew it up in the first instance, because it's their fault that it doesn't make sense. So that's great for yourselves as managing agents for the tenants in a lot of circumstances, because normally it's the landlord or managing agent for the landlord that draw up the contract. However, there will be a lot of circumstances where you're the ones that are drawing up the document. You're the one that are producing these clauses. So you've got to be very careful in terms of how they're being produced, to make sure you're actually getting across what you want to get across. A couple of tips for doing that: read it out loud, get a colleague to read it, because that way any mistakes that you've read or that you put in there will be highlighted. You just read through it in your head. I'm certainly guilty of this as well. If you read through it in your head, you read what you intended to read, or what you intended to write. Your brain makes the corrections for you, and you don't notice mistakes quite as easily. So really important to get that part sorted out at the earliest possible stage. Now, if you're looking to serve notice under a break clause, if you have multiple tenants, all tenants need to be serving notice under that break clause. One tenant can't serve notice on behalf of all of them. It needs to be all of them that are serving. It's different when the tenancy goes periodic, but if you are relying upon a break clause, therefore ending a tenancy during the fixed term, that is something you need to be aware of. Break clauses in general ideally should be as simple as possible. If you are having conditional break clauses, only ever have it on things that can be proven. Now, it may well be a business break clause. Maybe you're acting for a company where someone is coming over on secondment for an initial year, and then which might turn into years 2 and 3 afterwards, but they don't know for the time being. They might want to incorporate a break clause that entitles them to maybe end the tenancy slightly early in the event that they get pulled back earlier than expected. Business break clauses can be proven in terms of letterheaded paper from employers, or proof of where the office is actually located. Where people get into trouble with break clauses is where it's subjective, i.e. that it's things like if noise gets too much. Try to be careful in terms of doing something which could give rise to an argument. Only rely upon break clauses, ideally on things that can absolutely be proven. There has been a growing trend to try and relate these sort of clauses in relation to things like rent arrears. So tenants, if they fall into arrears, rather than landlords going through things like Section 8 notices or forfeiture procedure, then just saying they can serve notice on the basis of either an NTQ for a company let agreement or a Section 21 for an AST. In my view, this creates exactly the same problem as the forfeiture or Section 21 notice, in the sense that the same defences arise. If there's a reason for non-paying rent arrears, then it can give rise to saying there are no rent arrears because they're not due because of X, Y, Z. So conditional break clauses, ideally only ever get involved with them on things that can absolutely be proven. Equally, options to renew. Again, interpreted incredibly strictly. It gives the tenants the automatic right to force the landlord to extend the tenancy for a specified period of time. If you are looking to have a clause like this within there, try and make sure that it is as clear as possible as to what the obligations of either party should be. So if the tenant needs to serve notice, that they're doing so by a particular time, that it is dependent, and try and negotiate as many of the updated terms of any extension as you possibly can do. Because it's all very well and good forcing the landlord to extend the tenancy. If you then get into an elongated argument over what the terms of that tenancy should be, then it defeats the point of entering into something to force the landlord to extend. Yeah, you've got an extension, but you don't know the exact terms, and could get messy if court action might be needed at a later date. So try and make sure that if it is an extension, that you know how rental is going to be calculated. Is it going to be increased in line with RPI? Is it going to be on the same terms? Is the tenant going to have a break clause in any extension that's been produced? So try and think holistically at everything that might be proposed, so that you can make sure the clause is as full and complete as possible. Much less common, however, something which can be done particularly in relation to higher value properties or properties that are slightly longer for their fixed term, if there's individually negotiated terms that can be agreed. So let's say your clients want to repaint part of the property. Maybe it's their child's bedroom. They're going to be in there for a while, want to decorate it to fit what that child's going to want. Now, if you're producing a clause like this, make sure you're as specific as possible. You don't want an argument that the wrong color was used or it wasn't done correctly. So if you're producing a clause like this, try and think through all the different factors that you might want to take account of. So what exactly is going to be done? Which room is going to be repainted? Or is a shed going to be put up in the garden? Whatever it is. Who's going to do it? Is a professional going to do it? Is it okay if the tenant does it themselves? What time frames is there for doing the work? Who's going to pay for the work? What happens if either party fails to comply, i.e. that a different colour was used than was originally proposed? Or the landlord's going to do it and doesn't do it within the time frame that they say that they're going to do it? How is that calculation of compensation going to be calculated? So all dependent on what individually is negotiated, but it's crucial to try and establish that early on, so that if there is any non-compliance by the landlord, you've got a clause that you can enforce. Then you can show a physical loss as a result of a failure to comply with what the landlord should have complied with. Okay, so a couple of additional points that you can look to try and point out. Now, this often is not necessarily something that needs to be incorporated in any sort of tenancy, but certainly should be part of your procedure in getting answers from your landlords. One thing that is sort of missed quite a lot when tenants are negotiating with landlords is that if a tenant has a managing agent assisting them, in this case yourselves as their relocation agent, they are expected to know what questions there should be asked. There is less of an obligation on the landlord or managing agent to produce this information voluntarily. So if you are going into a tenancy, make sure you're asking as many questions as you can do and try and have them in writing, if at all possible, so that if it turns out any of that information isn't correct, you're entitled to go back to them to say, you didn't provide us with this information. So are any parts of the property going to be retained by the landlord? Are they going to retain office, loft space or the garage or anything like that? Do you have access to the garden? Is there a parking space included? Is there anything that might be particularly important to your client? So if they're working from home, is it going to be a noise issue that might be important? Therefore, ask if there's going to be any anticipated works in the neighbouring area. Are there any issues that they need to be aware of, like bad internet connection, non-working appliances? Does any work need to be done to the property to make sure it's ready for your tenants when they end up moving in? Because ultimately, what might be important to your client might not be the same to other parties. And so you need to be asking those direct questions to make sure it is suitable for your client. And then if necessary, if the landlord is going to be doing certain works to make sure that it is going to be suitable, you can use the provisions from the previous slide that we were looking at to produce a clause requiring that action to be taken, so that you've got a contractual claim for breach of contract if there isn't any compliance as far as the landlord is concerned. A couple of additional points in terms of the tenancy agreement, again, that you should be asking at the start of the tenancy. So how long is the tenancy going to last for? So is there going to be a break clause? Is it going to be say for an initial fixed term, and then how is it going to continue thereafter? So what a lot of managing agents and landlords are now doing is continuing tenancies on what's called a contractual periodic basis rather than statutory. So, i.e. statutory periodic tenancy is when a tenancy continues on a period by period basis. So if rental was payable monthly and it was for initial fixed term, it would be for an initial term of 12 months and then 1 month, 1 month, 1 month. If it was contractual periodic, it would be for an initial 12 months and then it's 13 months, 14 months, 15 months. So in those circumstances, there's different things that you need to be looking for with the tenancy. If it is a contractual periodic tenancy, you want to look to make sure that there is a termination clause in there, so you know what notice needs to be given to end that tenancy. Is there a rent increase clause in there? Again, probably not something that you want to be highlighting to your landlord in the event that that there isn't a rent increase clause in there. But if it's a contractual periodic tenancy, particularly if you're dealing with an AST, if there's no rent increase clause, there's no automatic right for the tenant or for the landlord to increase that rent. They don't have the Section 13 provisions that they would have for a statutory periodic tenancy because you're still in the fixed term. So look out for as much of this information as at all possible. Now, the reason a lot of landlords are going contractual periodic rather than statutory periodic is linking back to the super strike case from a long time ago. Which looked at statutory periodic tenancy being considered to be a new term that's being entered into, whereas a contractual periodic tenancy is just a continuation of the previous one. So make sure your client is aware of what their obligations will be, and that things like things like termination clauses, rent increase clauses, if they're in there, are ones that you know you can comply with. Now, the next couple of slides are mainly just so that you can refer back to them later on. They are obligations that the tenant will have. Now, the general provision within a tenancy agreement is that the tenant will have a lot of obligations, landlord will have very few. Now, normally that is because the landlord's obligations will exist whether they're in the tenancy agreement or not. Whereas if the tenant has obligations, then if it's not set out within the contract, then the vast majority are not ones that they necessarily need to make sure that they comply with. So if these are included within, these clauses will often be included as standard within the majority of the types of contracts that you're including. Now, again, depending on the importance of these particular clauses to your client, you might want to be aware that as to whether to highlight them to your landlords at all, if at all possible. Now, a couple ones I just want to go through really quickly. Be aware, stamp duty does apply for residential tenancies as well as sales. Only if the property is being let for either a long period of time, and so the cumulative rent for that initial contract is over the 125,000 threshold, or if it's just an incredibly high rent. So if you are dealing with those sort of tenancies, make sure your client is taking appropriate advice, because time frame for paying the appropriate stamp duty is within 14 days of the completion of the contract. So you don't have a lot of time to sort this out afterwards. What you need to do in the property, your tenancy agreement, again, will be fixed on these fronts and will be fairly conclusive. If they're not conclusive, then landlord's probably not going to have much of an entitlement to claim from things like the deposit. They are relying upon those contractual grounds as grounds for trying to claim the money. So a couple of ones that you need to be aware of for this from this is that things like treating the property in a tenant-like manner. Your clients will need to do what would be expected of a standard tenant. Now, this may well be replace light bulbs from time to time if it's reasonably accessible, clean out gutters, again, assuming it's reasonably accessible, not cause unnecessary damage to the property if it can be avoided. You will also have obligations to notify your landlord of any repair that needs to be carried out. Disrepair claims made by tenants against landlords require the landlord to actually know or should have known about the issue that had been reported. So make sure you're keeping that all in writing so that if you do need to rely upon that later on, you can then rely upon this contractual authorization and proof that you reported these issues in the first instance. Then an authorization to pay for repairs carried out without authorization if the landlord doesn't give a response within a certain period of time. This is ordinarily something the tenant is responsible for doing themselves. Pay for repairs if you don't seek the landlord's consent beforehand. This is often a clause that's included within a tenancy agreement, hence why you need to make sure you're going through it in suitable detail so that you're picking up on these sort of clauses. Because you may well, in certain circumstances where works need to be carried out, might require the tenant to actually do the works themselves because the landlord is not going to do it themselves. So make sure you're looking out for clauses of that nature. Landlord's obligations, again, normally will be set out within statute anyway, and so will apply regardless of their position or what the contract actually says. A couple of things to make sure that that you're sort of looking out for: making sure the landlord's complying with the necessary safety regulations and providing that to your client before they ever take occupation of the property. And has a suitable data protection policy. Now, this may be the management agent that is using this, but that they have a privacy policy, that they're going to use your information correctly, that it's not going to be passed on to people that they don't have authority to pass it on to. Final one that you just want to make sure that you're highlighting is apportionment of rent. Make sure there's a contractual entitlement, particularly where you've got things like break clauses, that the rental needs to be paid back to the tenant if it is overpaid, because there is no automatic requirement for the landlord to do so. If the tenant serves notice in accordance with the break clause and the notice expires midway through a period of the tenancy, technically that tenant is responsible for that entire period of the tenancy. Not going to happen very often, but if you've got a situation like that, you're going to want a clause in your contract that entitles the tenant to this money back. Final thing that we're going to cover, and then a couple of questions. I appreciate the fact we're overrunning slightly on this on the course. Electronic signatures, as far as the Law Society is concerned, are absolutely fine, enforceable way to enter into a contract. Not something that should be scared, that you should be scared of. One thing to be aware of, though, is you need to be familiar with your electronic signature company. If you're the one that is using that, great. If it's the managing agent for the landlord that's initiating this process, that you're aware of what their policy is with it, because not all systems are the same. There will be some which send out copies to landlord and the tenant separately, and as soon as they sign, it is automatically exchanged and completed. Now, at that point, it's a binding agreement on all parties. That might be before your client is ready to have exchanged the contracts. But equally, it's something you can use to your advantage if the landlord is not able to sort of hand over possession of the property, because you are entitled to rely upon that contract. Equally, it may well be that it's sort of in essentially privacy mode until the managing agent is able to execute the contract, which will normally be when they are satisfied that they're definitely entitled to enter into the contract, i.e. that the current tenants in the property have left, that they've done the gas safety, they've done the electrical safety checks, they've got an up-to-date EPC. Everything that they are required to do has been satisfied, and they've got the first month's rent and security deposit from your clients. So make sure you're investigating at that stage, because not all electronic signature providers are sort of correct or the same on that point. The final thing to be aware of is that electronic signatures, the same report that was conducted by the Law Society that said contracts are absolutely fine, gave recommendations for how deeds could be used. So it's not that they can't be enforceable by virtue of electronic signatures, but things like webcams that that show that someone else was in the room at the same time were proposed as a way to make this sort of process a bit better. So there is no categoric way that someone could say with absolute certainty that this other person was definitely in the room when this document was signed. I appreciate that they track IP addresses, that they show it was the same computer, but you need to show it was a different person that was there when doing so. Again, it's probably slightly less of an issue for yourselves as the tenant. However, it will normally mean that, certainly if they're being well advised, that landlords and agents might insist, if they're entering into things like deeds, because the contract is, say, over 3 years, or they want a deed of guarantee entered into or anything like that, that they might insist on a wet ink signature rather than using the electronic signatures for it. Right. Okay. That's pretty much it for this initial talk. Anyone that obviously does need to head off, because I appreciate it was just originally for the hour, then do so. I'm going to go through any questions that anyone does have now. So put them in the chat box. I know a couple of them have already come through, so I'll go through those in just a second. But yeah, if there's any other questions, then just let me know. Right, okay, let's see where we left off with last time. Okay, so Alexandra asked, with a renewal and a small increase of rent, should the deposit be changed? It's very rare that a landlord will ask for an increased deposit, mainly because they can get so much wrong with the protection of a deposit. Technically, they are entitled to ask for it, but it is very, very rare that they would put that burden on themselves. So technically it means they might be entitled to a slightly bigger deposit. It's not one that you need to pay. And again, not something that I would normally recommend if I was advising a landlord to start messing with the deposit partway through. Can you just confirm your email address? Because I think you need to send.
No, don't worry about that. That's me.
Yeah, great. Can you sensibly mix, for example, a 6-month break clause and an option to renew for a second year as applicable? So the problem with having a break clause and an option to renew is they're completely contradictory in nature. One entitles a contract to end early, and one entitles an automatic right to extend. So I would never look to have a break clause and an option to renew if the landlord has the ability to break. If it's a tenants only break, it's fine, have one in there. The problem with that is that the case law is incredibly old. I believe it's from the 1800s, sort of indicates that a break clause would take precedence. However, old case law would be based on individual circumstances, and it's creating an argument that you really don't want to get involved with. So if you want an option to renew, but your landlord is looking for a break clause for themselves to end the contract, they're probably going to use so before you use your option to renew. So given the fact that by having an option to renew, it normally means that your tenant is paying a slightly bigger premium in terms of the rental for that option, it's less useful for them if there's a break clause entitling the landlord to end earlier. Alexandra, I've been told by an agent that a tenant option to renew is stronger than a landlord break clause. Again, I tend to disagree with that. I think that if there's an ability to end the contract early, I think the break clause would take precedence in those circumstances. Not guaranteed, but that would certainly be my view. Jay's asked, is stamp duty due at the start of the tenancy? For example, if it was a 3-year tenancy, would stamp duty be at the start of year 3 of the tenancy? No, it'd be due at the start of the tenancy. If you happen to end the contract slightly earlier, then it might be something that you can apply to HMRC for that money back. You are never really going to get that money back. It is the value of that contract that you are agreeing to, and so payable right at the beginning. This would apply even if you've got, say, options to renew, because the potential value of that contract is greater than, or would be greater than the SDLT sort of threshold. Jay's asked, if a landlord is overseas, is it legally required to have an address for the landlord other than a carer for the managing agent in the UK? So the only requirement as far as a landlord's concerned is that they need to make sure that they've provided a residential address for the landlord. Now that can be abroad. However, in the event that the landlord's address is abroad, they need to provide an address for service of notices within England and Wales. They need to comply with their section 47 and 48, the Landlord and Tenants Act requirements. That can be the managing agent though. They don't need to have a residential address of their own in the country, but they do need to provide that address. So if the address for service of notices is abroad, then no rent is legally due until such time as this address has been provided.
That looks to me as if that's the last one, unless anybody's got any questions at this point. Well, if no one's going to raise a hand or ask any questions, then I'm going to say thank you very much, Richard.
No problem at all.
Wait a minute.
Yep, well, questions come through.
Oh no, it's come back with 2.
Right, so if the initial fixed term is 1 year and you have asked for a 6-month break clause, does it contradict it? Break clause can only be exercised after the initial fixed term of the tenancy. In most cases, it is just the first 6 months of the tenancy unless a different break clause been otherwise agreed in writing. So a break clause is only to end a contract early. So once the initial fixed term is expired, there's a break clause isn't applicable anymore. So the only reason you would have a break clause is to end that initial contract. Once the initial fixed term is expired, you either negotiate the terms of a new extension. If it's a contractual periodic tenancy, then you have that termination clause in your contract, or it's gone statutory periodic, which will require either Section 21 notice in the event of an AST, notice to quit in the form of a company let's agreement. So the break clause really, if it is going to be ending an initial fixed term early, needs to set out the exact criteria that you can do so. And once that fixed term has expired, then the break clause isn't applicable anymore because you're not ending a fixed term early anymore.
There's another one here just popped up.
Yeah, if the initial term expires and no notice is served by the landlord, does an agreement automatically enter a periodic tenancy? So yeah, it does. It will either be statutory periodic if your tenancy agreement makes no reference to how the contract is going to continue, or if your contract says how the contract will continue thereafter, i.e. on a contractual periodic basis, contractual month-by-month basis, determinable by either party serving 2 months notice or whatever it is. If it's in your contract, then it may be a contractual periodic tenancy that is created, but there is some sort of ongoing tenancy that is being in existence.
Okay, is everybody any more before we close this session? Obviously look forward to seeing you next week. For those of you who don't actually know me, I am Tad, not Dominic. It's just that we're using a system that we use for Euro sometimes. And we haven't done this before in terms of the ARP, but I'm sure hopefully you've all found it very useful. As Richard said at the beginning, if after next week's you have or want to do more like this, we can arrange them and maybe make them a little bit more topic specific. We'll see. Anyway, this is just thank yous from various different people. I'm going to say thank you very much to everybody, and I'm going to end the session right now. Thank you. Oh, more thank yous. Here we go. Okay, right. Anyway, we'll look forward to seeing those of you who are participating next week. Thank you, Richard. Thank you, everybody. And it's goodbye from me.